Hi, this is Attorney Haji Hidlaw, and welcome to my channel, Demeter Pharma. Now guys, if you like my videos and my discussions, please don't forget to hit the subscribe button and share our videos. Thank you and God bless.
Hi, this is Attorney Haji, and welcome to Demeter Pharma. Hi guys, let's start our Module 3 on Delay and Fortuitous Events. Okay, let's discuss first delay. Okay, now, ano yung concept ng delay? Guys, bagong lahat, kumusta sa mga estudyante ko sa Pasay City College? And just sit back, relax, and enjoy the presentation. Okay. Delay. Guys, ngayon na 11-11-11, uso ang Lazada at Shopee. Okay. So, dito, sila ang maging examples natin sa concept ng delay. Okay. Now, sa concept niyan, delay or default or mora is the non-fulfillment of an obligation with respect to time. Okay? So, dalawa yan. Ordinary delay, which is merely the failure to perform an obligation on time, or legal delay or default or mora is the failure to perform an obligation on time, which failure constitutes a breach of obligation. Okay? Next. Okay. So there are three kinds of delay. The first kind is mora solvendi, mora accipiendi, and compensatio morae. So isa-isahin natin guys. First, mora solvendi is the delay on the part of the debtor to fulfill his obligation, to give or to do by reason of a cause imputable to him. Mora accipiendi, or the delay on the part of the creditor without justifiable reason to accept the performance of the obligation. And third, compensatio morae, delay of the obligors in reciprocal obligations, like in sale. Example, the delay of the obligor cancels the delay of the obligee, and vice versa. Okay. Let's discuss first mora solvendi. Okay, guys? Mora solvendi. Ano ito, guys? Okay. In mora solvendi, the delay is on the part of the debtor. Now, a while ago, I promised you that we will discuss what? We'll make as examples Lazada and Shopee because it's 11-11. Okay. In more solvendi, guys, the delay is on the part of the debtor. Now, sino yung debtor dito sa case ng Lazada at ikaw na nag-order? Now, guys, the debtor here is Lazada or his partner merchants, while the creditor is ikaw. Okay, why? In this case, the debtor will fulfill his obligation to give or to do. Okay? So, here, the debtor or Lazada has an obligation to deliver a the package which you order. So any delay on his part has the following effects. Okay? So, if there is delay, the debtor is guilty of breach of the obligation. He is liable for interest in case of obligations to pay money, and he is liable even for a fortuitous event when the obligation is to deliver a determinate thing. Lalo na guys, in this case, lalo na yung mga bayad na sa in-order nila. Kasi guys, hindi lahat ng nag-order ay cash on delivery. May iba na chinarge na ito sa kanilang credit card. Now here, the partner merchants is duty bound, is obliged to deliver the parcel or any property na in-order mo sa Lazada or sa Shopee. Okay. So, yan yung mora solvendi, yan yung effects niya. Now, in mora accipiendi, the delay is on the part of the creditor, which is you, without justifiable reason to accept the performance of the obligation. So, sa creditor, which is ikaw yung nag-order, kung nag-deliver sa'yo ni Lazada or ni Shopee ang package at hindi mo siya tinanggap without justifiable reason to accept the performance of the obligation, the creditor will be liable. At ano yung effects nito, guys? Okay? The creditor is guilty of breach of the obligation. He is liable for damages suffered, if any, by the debtor, and he bears the risk of the loss of the thing due. Okay? Kung ayaw mo tanggapin yung dineliver na item, kasi sabi mo, for any other reason, kung nawala yan or na-damage yan, hindi yan liability na nag-deliver sa'yo. Kasi ikaw yung nag-ayaw na tanggapin. Okay? So third, let's go to compensatio morei. In compensatio morei, the delay is on the part of the obligors and the obligee. So in reciprocal obligations, like in Lazada and you na nag-order, in compensatio morei, there is delay on the acceptance of the obligation and delay on the fulfillment of the obligation. So, such as in the contract of sale, hindi nagbayad, hindi rin nag-deliver. So, yun. Quits lang sila. Okay? So, gets nyo yung concept ng kinds of delay, ha? Next. Requisites of delay or default by the debtor. Okay. So, number one, it's the failure of the debtor to perform his obligation. Like, on the date agreed upon. Example, guys. In a contract of loan where X borrowed money from Y last January 2020 and he promised to pay today kasi nga 11/11, the failure of the debtor, the one who borrowed the money, si X, is to perform the obligation, which is to pay the loan amount kay Y. Okay? So, sa delay is you need, number two, the second requisite is demand. Not mere reminder or notice made by the creditor upon the debtor to fulfill, perform, or comply with his obligation, which demand may be either judicial or extrajudicial, orally or in writing. And 3, failure of the debtor to comply with such demand. Okay? So guys, requisites ng delay number 1, there must be failure of the debtor to perform his obligation. Number 2, there is demand. And 3, there is failure of the debtor to comply with such demand. Guys, ano yung napansin nyo dito? Okay? Demand. You need to make a demand. If there is no demand, there is no delay yet. Okay? So, kailangan meron demand, either judicially or extrajudicially. So, pag sinabing judicially, it is filed in court. However, in extrajudicially, it is made orally or in writing, which in our legal system, ang demand para makapag-claim ka, kailangan may proof. Meaning, it should be in writing. Okay? Clear yan ha? So, okay. However, exceptions. Okay? Exceptions doon sa rule na demand. When demand is not necessary to put debtor in delay. Okay? So, ang general rule, delay begins only from the moment that the creditor demands, whether judicially or extrajudicially. Tandaan nyo guys ang general rule, delay begins only from the moment the creditor demands. Okay? Either in writing or by filing a case. Okay? So, without such demand, the effect of default will not arise unless and any of the exceptions mentioned below. Okay. So, ano daw to? When the law, first exception is when the law provides. Example. So, in taxes, upon payment of taxes, April 15 or March 15, where the law provides for payment of penalty if the obligation is not performed on due date, then demand shall not be necessary. So, nakalagay yan sa batas or any rule promulgated by competent authority. Okay? That's number 1. Number 2 naman, when the obligation expressly so declares. Okay? When the obligation expressly when the obligation expressly so declares, demand is not needed. Example, the rental should be paid by the lessee within the first 5 days of the month in advance without need of demand. Okay? So, kung napag-usapan nyo na ito before the commencement of the contract or the obligation, clear siya dyan. Okay? Number 3, when time is of the essence of the contract. Example, where a rent car company is obliged to provide for the bridal car during a wedding at a particular date, time, and place, said company is liable if it fails to perform the said obligation, notwithstanding the absence of demand. Guys, this is common sense. Kaya ka nga kinuha na bridal car is kasi may kasal. Ngayon, kung hindi ka nag-attend ng kasal, hindi mo pinuntahan yung what's this? yung bride hindi mo sinundo, you will be liable for untold damages. Kasi nga, rent a car ka nga. And you need not, paano yun? Hindi na kailangan na tawagan ka pa, mag-demand ka pa, kasi time is of the essence. Okay? Clear yan ha? And number 4, when demand would be useless. So, example nito, the debtor will be delayed even without demand from the creditor. If the thing he is obliged to deliver has been destroyed through his fault or has delivered it to another person. So, if the thing that you ought to deliver has been destroyed, hindi ka nakapag-comply, even if there is delay, hindi na kailangan na mag-demand pa yung creditor. Example guys sa Lazada, bayad na yung parcel. Now, you will just deliver it. However, if with even with the, because of your negligence or kapabayaan, na destroy yung order, then even if without demand, you are liable. Ito guys ha, uso to ha, he has delivered it to another person. Okay? And in reciprocal obligations, where the obligations arise out of the same time. So, there is delay by the other begins notwithstanding the absence of demand. Demand is not necessary in reciprocal obligations. Okay? So, that's clear. The concept of delay. So, ulitin natin na, mora solvendi is the delay on the part of the debtor. Mora accipiendi is the delay on the part of the creditor. And compensatio morae is the delay of the obligors in reciprocal obligation. Okay? Next, we will discuss fortuitous events. Hi guys, we're back. Now we discuss fortuitous events. Okay guys, recently we just experienced the one of the strongest typhoons, if not the here in the Philippines. Typhoons are but a necessary occurrence every year. So what do you do when these typhoons come to our place? We brace. We take the impact, then we move on. Okay. Now guys, a typhoon is an example of a fortuitous event. What is a fortuitous event? It is any event that is an extraordinary which cannot be foreseen or which though foreseen is inevitable. Okay? In other words, it is an event which either is impossible to foresee or impossible to avoid. The essence of a fortuitous event consists of being a happening independent of the will of the obligor, and which happening makes the normal fulfillment of the obligation impossible. Okay, guys. Now, for it should be distinguished from into two kinds. Okay, a fortuitous event which is considered as an act of man or an act of God. What is an act? What are acts of man, which is also a fortuitous event? Strictly speaking, fortuitous event is an event independent of the will of the obligor, but not of any other humans like war, fire, robbery, murder, insurrection, accidents. These are acts of man. How about the other kind? Acts of God. They are those events which are totally independent of the will of every human being, like earthquake, flood, rain, shipwreck, lightning, eruption of volcano, etc. They are also called force majeure. The term generally applies to a natural accident. Okay. Now, in our law, fortuitous events and force majeures are identical insofar as they exempt an obligor from liability. Both are independent of the will of the obligor. Now, in insurance cases, guys, nakalagay dyan is acts of God. So, in insurance cases, only acts of God are covered, which are typhoons, earthquakes, flood, rain. However, if it's acts of man, it refers to insurance of a different thing. Okay, we proceed. Now, what are the requisites of a fortuitous event? The event must be independent of the human will or at least of the obligor's will. And B, the event could not be foreseen or it could be foreseen, which must have been impossible to avoid. Okay? Now, third, the event must be that of such a character to render it impossible for the obligor to comply with his obligation in a normal manner. Now, last, the obligor must be free from any participation in or the aggravation of the injury. Take note, guys, that in order for this event to apply, to exempt the obligor from compliance, that is that these four requisites must must happen. Okay? So, examples ng ganito. First example, if X is engaged in the business of carrying passengers for hire or for delivery. However, when X engaged when Y engaged the services of X, one of the what's this? One of the um drivers dun sa uh, transportation business of X is not a licensed driver and is not even a what's this? It's not even a an employee of X. So, during the travel, kumbaga, itong driver na to ay nag short time lang sa na mag-deliver ng cargo kay Y. So, nasagasaan um nasagasaan ngayon yung kumbaga na aksidente yung na aksidente yung truck na nagde-deliver. Okay? Okay. Let's start. Example sa examples. Okay? X engaged in the business of carrying passengers for hire. Undertook to convey B and C from one point to another in an automobile. The automobile was operated by a licensed chauffeur who later allowed his assistant who had no license but had some experience driving to drive the car. Now, defects developed in the steering gear after zigzagging from a distance. So, the car turned turtle and the passengers, B and C, suffered physical injuries. Now, guys, is X, the company, the one who was engaged to carry B and C, liable for damages? Yes, X is liable for damages because he violated the contract for not delivering PNC to the proper place. Okay, that's a contract of carriage. And there is no, what's this? There is no contributory negligence from BNC in the problem. Okay. Next example is a contract of also a contract of delivery. We mentioned before that in Lazada, in the delivery of Lazada packages, guys, nag-order kayo ng package sa Lazada, 11/11. Okay? So, nung nag-order kayo, X, the private company, the seller was obliged to deliver the, halimbawa, this cell phone. Okay? This cell phone is supposed to be delivered when? After 10 days. Now, because of the bagyo, okay, because of a typhoon and extreme flooding happening in regions 1 to 5 and Metro Manila, especially Marikina, is X, the company of Lazada, still liable to deliver under the rules of fortuitous event? Ano, isa-isahin natin. The event must be independent of the human will. The event could not be foreseen, or it could be foreseen but must have been impossible to avoid. And the event must be such of a character to render it impossible for the obligor to comply with his obligation. And the obligor must be free from any participation in or the aggravation to the injury of the obligee. Now guys, nagbayad na kayo sa Lazada because if it is not cash on delivery, bayad na kayo. Bayad, kumbaga, bayad na yung cellphone na in-order nyo sa Lazada. Paano yan? Nagbagyo. Nabaha yung kumpanya kung saan kayo nag-order. Paano na yung phone na in-order nyo? Event. The typhoon, the flooding in Marikina. For example, sa Marikina, yung in-orderan nyo ng cellphone na to. Is it what? Is it independent of the human will? Yes, the typhoon is independent. Could it be foreseen? The flooding in Marikina could be foreseen. Yes. But is it unavoidable? Yes. Floodings are unavoidable consequences. Kasi nga, sobrang dami ng tubig na lumabas dun sa typhoon, and almost everyone is affected by the flooding. So letter C, is it impossible for the obligor to comply with his obligation in a normal manner to deliver it in 10 days? Also yes. Kasi nga na wash out yung anong tawag niyan? Na wash out yung office ng magde-deliver ng cellphone. So, syempre wala din siyang participation. So, paano ngayon 'yan? The one who ordered the item to Lazada can avail, although it's a fortuitous event, walang damages, but can only demand for a money back return of his payment. Okay? So, ganun guys yung mangyayari. Okay? So, maliwanag yun ha. Next, we proceed. So, a person, as a rule, is not responsible for loss or damage resulting from fortuitous events. except exception, guys. Okay? So as a rule, pag may nangyaring kalamidad, yung taong mag-deliver is not liable for damages except when expressly specified by law. Okay? So, halimbawa, ano yung mga express specification, express law. So, the debtor is guilty of fraud, negligence, or delay. If halimbawa, na-delay yung pag-deliver, kasalanan na po yun ng nag-deliver even if nabagyo siya. So, after the 10th day, if the item was not yet delivered to you, that is considered as delay. And nag-demand ka, don't forget guys, you need to make a demand. Okay? So, next. When declared by stipulation. Okay guys? So, pag nakalagay sa kontrata na you need to deliver the thing at the proper time and in the proper place and hindi siya na umabot doon, um, liable siya sa any damages even if there is a fortuitous event. Okay? Clear yan ha? Next. Okay. So yun. Yun na yung mga exceptions sa okay. Third, meron pa pala. Sorry guys. When the nature of the obligation requires the assumption of risk. Halimbawa nito guys is yung mga insurance companies. Okay? So, pag insurance, liable talaga siya kasi nga insurance yung business niya. Okay? Yun yung last. Okay. So, that would be all for okay. Impossibility of performance also must result from occurrence of fortuitous event and not from negligence. Okay? So, ang purpose ng releasing the debtor from his obligation is must be the occurrence of the fortuitous event. Okay? If it's not from fortuitous event, syempre liable pa rin yung debtor. Okay? And that would be all for fortuitous event. If you like my discussion, please don't hesitate to subscribe and share my videos. Thank you and good luck.